our discussion this evening will focus on the crimes against the law of nations. So it is provided under Article 118 until Article 122 of the revised penal code. So Article 118 provides the crime inciting to war or giving motives for reprisals. Then Article 119 of the revised penal code, it is the violation of neutrality. Then Article 120, correspondence with hostile country. Article 121, flight to enemy's country. And we have this piracy in general and mutiny on the high seas. Okay? So that are the points that we'll tackle this evening. Okay? We have already finished with the treason last time. Okay, we'll proceed. So, as I have mentioned, class, in our previous discussion, the focus here in criminal law are more on the book, especially book 2, are more on the elements of the crime and the penalties. Okay. So, if it will not go on class, if the elements are lacking, then it cannot be considered as you have not violated the law, or it cannot be considered as crime. Okay. So in crimes against the law of nations, the offender can be prosecuted anywhere in the world, because these crimes are considered against humanity in general, like piracy and mutiny. So it means to say, class, that if you have violated this act, if you are a Filipino citizen and you have violated this act here at, say for example, Malaysia, it does not mean to say that you will invoke the exemption as provided for under the revised penal code article 2, the exemption of territoriality. Because as again, class, it is one of the exemption of territoriality. It extends beyond the border of the Philippine territory. So, if you have committed inciting to war or giving motives for reprisals there in Malaysia, even if you are a Filipino citizen, then you may be charged there for the acts. Or if you are, or vice versa, if you are a Malaysian resident and you have engaged incite war or giving motives for reprisals here in the Philippines, you may be charged of the uh, said law, of the said violation of the Article 180. So, crimes against nationality can be tried only in the Philippines, as there is a need to bring the offender here before he can be made to suffer the consequences of the law. So the acts against national security may be committed abroad and still be punished under our law, but it cannot be tried under foreign law. Of course, class, in my example, if the Malaysian government will provide that the penalty for inciting to war or giving motives for reprisal, then they may charge the said person there in the jurisdiction of Malaysia. And in example, second example, vice versa, if you are a Malaysian resident or citizen and you have committed the violation of any of the crimes of national laws here in the Philippines, you may be charged here. However, if you are not found here in the Philippines, then of course, class, you cannot be tried, because jurisdiction of the court can be acquired only by voluntary surrender or by they call enforcement of the law, such as warrantless arrest, search and seizure, or warrant of arrest, just like that. So, what are the elements of inciting to war or giving motives for reprisal? So, we have here the first element class is that the offender performs unlawful or unauthorized act. So, that such acts provoke or give occasion for a war involving or liable to involve the Philippines or expose Filipino citizens to reprisal on their
Yes, sir.
persons or property. Yes?
Ang karon ako, sorry sir, karon ako sulod sir, nagatindan sa sir.
Paminaw. Ano ba? So, crime is committed in time of peace. Intent is immaterial. Of course, class, uh, you you cannot be charged of you cannot be charged of inciting to war if the Philippines is not at war. Okay, so that is why it is in time of peace. So intent is immaterial. Okay, inciting to war offender is any person. The reprisal is not limited to military action. It could be economic reprisal or denial of entry into their country. Economic reprisal class, it means kaning di prohibit nila ang pag-entry sa, say for example, goods that are beneficial to our country. The reason for it is for them to suppress the production thereof of, say for example, the production of petroleum here in the Philippines, so that they would supply, did not supply, they cannot supply here in the Philippine market, then of course it may be considered as a reprisal. Okay. Example, X burns Chinese flag. If China bans the entry of Filipinos into China, that is already a reprisal. Okay. That's example of reprisal. Okay. So that's the element, that's the important gist of inciting to war or giving motives for reprisal. Violation of neutrality. What do you mean by this? Elements that there is war in which the Philippines is not involved. Say, for example, the war against war against uh, Ukraine and Russia. So there is war there, but the Philippines is not player thereof. Or Israel versus war against Israel and Palestine. So the Philippines is not involved in such war. Okay. Then that there is a regulation issued by the competent authority for the purpose of enforcing neutrality, and that the offender violates such regulation. So it means, class, that the government should have, or the Congress should have said that, oops, the Philippines will not, there is a Republic Act issued by the Congress that the Philippines will not join any war or will not give aid or comfort to either of the country in which there are wars, say, just like Ukraine and Russia. But however, on that matter, class, there is no statement of the Congress that there is a neutrality, because as far as my knowledge is concerned, we are ally of the U.S. government, and since we are ally of the U.S. government, if they will say that they will provide one, and they would ask the Philippines that they will provide something to show support to the the other state, then the Philippines, as the signatory thereof or an ally thereof, will extend help to that country. Okay. So government must have declared the neutrality of the Philippines in a war between the two other countries. So The regulation must be issued by competent authority like the President of the Philippines or the Chief of Staff of the Armed Forces during a war between different countries in which the Philippines is not taking sides. So it is neutrality of the Philippines that is violated. So Congress has the right to declare neutrality. The violation can be done either by means of dulo or by means of pulpa. So violation of neutrality can be committed through neckless imprudence. Example of this class is going to the command. Say for example, Israel going to Israel embassy. So extension of the territory of Israel here in the Philippines, then you would protest there. Mag-protest ka. So you will be charged with violation of neutrality if the president nagwalga ka dito, or say for example just like that. But of course you will not be covered if there is no declaration of neutrality. That's the very gist there, klasa. So if nagwelga, if you are causing a rally there, but there is no prohibition of neutrality that the Philippines will perform, then you will not be charged as such. Okay? Then correspondence with hostile country. Okay? That it is in time of war in which the Philippines is involved. Of course, class, there is war in which the Philippines is involved. And the vendor makes correspondence with enemy country or territory occupied by the enemy country. Note the correspondence is either prohibited by the government or carried on in a cipher or conventional signs. Cipher class, kaning mga magazine. Sa una pa manggod ni. However, now, it can be carried due to kaning mga cellphones, emails, like that. Or containing notice or information which might be useful to the enemy. So I believe class there is no kaning update regarding this matter, because if you could recall in your book 1, the Spanish, we are still using the Spanish text sa paningtuiga. Okay, so the correspondence is as I have mentioned. Then circumstances qualifying the offense. We have notice or information might be useful to the enemy. Then offender intended to aid the enemy. Hostile country exists only during hostilities or after the declaration of war. What do you mean by that? So it means, class, that there is already, meaning the war is already over, but still it is hostile. Na hostile siya, meaning they are not yet they did not follow order to the country in which it wins the war. Because class, in times of war, those who are winner of the war, just like the US versus the Japan war, World War II, since the Japan lost, so they are Japan is they are at fault. So if you lose the war, you are considered at fault. So if you not follow the restriction imposed or the condition imposed by the winning state or the ally thereof, then so you can be considered as hostile country. Meaning from the term itself, hostile or contra. Okay. Correspondence to enemy country. Correspondence to official of enemy country, even if related to you. Okay. So it is not correspondence with private individual in enemy country. So, sa parenthetic class, if ciphers were used, no need for prohibition. If ciphers were not used, there is a prohibition. Itong, if you are familiar with the war movies, kasi mga cipher, mga mo, decipher pa rin mo, kanay mga code, mga Morse code, like that. This one form of cipher. In any case, it must be correspondence with the enemy country. So doesn't matter if correspondence contain innocent matter, if prohibited, punishable. So if it is, of course, class, it must be declared that there is a kuan Japan. There is a prohibition which in the people will interact with the other country. Okay. For a while, kas ha? We'll serve 2-minute break. Hindi sakit ko mata. Of the sa video sa ko ang laptop. For a while, kas. Okay. Are you following, class?
Yes, sir.
Yes, sir.
Yes,
Okay.
sir. Yes, sir.
Okay. So we'll now go to piracy. Okay. So piracy, what do you mean by it in vernacular class? It's pirata. Pirata. So two ways of committing piracy. Okay. By attacking or seizing a vessel on the high sea or in the Philippine water. And nakadua, by seizing the whole or part of the cargo of said vehicles, its equipment or personal belongings of its complete complement or passengers. So the elements, the vessel is on the high seas or Philippine waters. Of course, class, you can, of course, class, piracy can be committed only by hijacking. O ano, hijacking is in the kaning aerial. So, if it is in the kuan class, kaning airplane, it is not considered as piracy. It is considered as hijacking. High, from the term itself, high, taas mo. So, piracy. So, what are the elements? As provided for, a vessel is on the high seas or Philippine seas. Ayun, that the offender are not member of its complements or passenger of the vessel. So, the offender attack or seize that vessel, or hence, if committed by a crew or passenger, the crime is not piracy but robbery in the high seas. Remember that was, huh? If the crew or passengers are the one who caused the seizing or attacking of the vessel, it is called robbery in the high seas. Okay? But those attack or seize of the vehicle, if it is done by any other person other than the crew or the passenger, then it is called piracy. Okay? Seize the whole or part of the cargo of said vessel, its equipment or personal belongings of its complement or passengers. Okay? So, high seas, it means any water on the sea coast, which are without the boundaries of the law, watermark, although such water may be in the jurisdictional limits of the foreign government. So, as I have already mentioned, the Philippines, the Philippine archipelago comprises of the internal waters, the maritime zone, the exclusive economic zone, and the territorial waters. So the territorial waters of the Philippines are the at least 22 nautical miles from the continental shelves thereof. So meaning of the continental shelves class, the lower part of the uh, landmass extending beyond the territorial internal waters of the Philippines. So meaning ano sa class, 'di ba? Uh, if you are in the ocean, or say for example if you are in the beach, 'di ba? Ang maligo ang 'di ba napamay siya yuta, paghubas, hubas anak class. Di katong pinakalalom, pinaka-last na bitaw nga na ay pag kuanin mo dito lalom na dayon sa diretso nga dagat, mao to siya gitawag ng continental shelves. So ano siya, 22 nautical miles ang yang the law provides 22 nautical miles. Then after that class, sa 22 nautical miles, na it covers na po ang 12 nautical miles over exclusive economic zone. AZZ ang tawag. That is why there is a conflict between the kaning sa South China Sea and the claiming and the West. Because of that, that is why when we say exclusive economic zone, it means to say that the Philippines are entitled to all the maritime all the maritime products within the exclusive, that is what we call exclusive economic zone. However, since the Chinese government has more equipment and high equipment than us, so we are considered as bullies, na bully na gid ta class. And it is not proper na and it is not di ta makaalig-alig o ganing si tawag gani kontra ana sa ila. Okay? Ayun, piracy in the high seas, it means to say that jurisdiction is with any court where offender are found or as arrested. Example class, if you are arrested at Malaysian government, then you are tried at the Malaysian court. Piracy internal water, jurisdiction is only with Philippine courts. For purposes of anti-fencing law, piracy is part of robbery and theft. So meaning class that it is absorbed. So there is a distinction between piracy and mutiny. So piracy means that robbery or foreseeable degradation on the high seas, while mutiny, it means that unlawful restraint to a superior officer or the raising of commotion and disturbance on board a ship against the authority of the officer. So meaning class, you are same ning aklas, that's the term class, it's mutiny. Proper terming aklas ba? So resisting a superior officer. In robbery or forcible degradation of the high seas without lawful authority and done with animo lucrandi. What do you mean by that? Animo lucrandi, it means that kaning ganahan ka mo possess o mo to take over the spirit and intention of universal hostility. Intent to gain is an element, no criminal intent. Attack from outside, attack from inside. Offender are strangers to the vessel. So mutiny, they are crews and members. So under the amended article, piracy can only be committed by a person who is not passenger nor member of the complement of the vessel, respective of venue. So if a passenger or complement of the vessel commits acts of robbery in the high seas, the crime is robbery, not piracy. Even the Philippines, Philippine water, still piracy. Okay? Hope you follow that class. Okay. Okay. However, despite the amendment, PD number 532 may still apply where the offender is not stranger to the vessel, since it provides any attack upon or seize of any vessel or the taking away of the whole or part thereof or its cargo, equipment, or the personal belongings of its complement or passenger, irrespective of the value hereof, by means of violence against or intimidation of persons or person things, committed by any person, including a passenger or member of the complement of said vessel, in Philippine water shall be considered as piracy. The offender shall be considered as piracy and punished as herein provided after all under the revised penal code. For one to be called pirate, the offender must be a stranger to the vessel. While the Article 122 limits the offender to non-passenger or non-member of the crew, PD 532 states that the attack upon or seizure of any vessel or taking away the whole or part thereof or its cargo, equipment, or personal belongings of its complement or passenger committed by any person, including a passenger or member of the complement of said vessel, shall be considered piracy. Okay. So class, under PD 532, you can be charged with the offense if you are a passenger of that vessel. Una katong robbery, you are considered as a robber. And then because of the PD 32, then you are also charged with the uh, piracy as provided for under PD 532. Note, however, that in Section 4 of PD number 532, the act of aiding pirates or abating piracy is penalized as a crime distinct from piracy. Tabangan mo. Said section penalizes any person who knowingly and in any manner aids or protect pirates, such as giving them information about the movement of the police or other peace officer of the government, or acquires or receive property taken by such pirates, or in any manner derives any benefit therefrom, or who directly or indirectly abets the commission of piracy. Also, it is expressly provided in the same section that the offender shall be considered as an accomplice of the principal offenders. Oh, so you are considered as accomplice and punished in accordance with the revised penal code. This provision of PD number 532 with respect to piracy in the Philippine water has not been incorporated in the revised penal code. Neither may it be considered defealed by number RA, since there is nothing in the material law is inconsistent. So, there is still the crime of abetting piracy in the Philippine water under PD 532. As I have mentioned, you will be charged with different offenses. Considering that the essence of piracy is one of robbery, any taking in a vessel with force upon things, or violation or intimidation against person is employed will always be piracy. It cannot coexist with the crime of robbery. Robbery, therefore, cannot be committed on board a vessel, but if the taking is without violence or intimidation or force upon things, that crime of piracy cannot be committed but only theft. Okay. So there are three distinct crime that can be considered a class. We have the robbery, the piracy, and the theft. So theft class if there is no presence of force upon things. Okay. So robbery there if there is a force upon things, but as provided for under this rule, it cannot coexist with the crime of robbery. But it does not prohibit the prosecutor from filing a case of robbery and piracy at the same time because you may sir, double jeopardy. Of course not, class. Why? Uh, it is provided for under the revised penal code and the other one is provided under special penal laws. Okay. So elements of mutiny. Okay. So the vessel is on the high seas or Philippine waters. Offender are either member of its complement or passenger of the vessel. So if offenders either attack or seize the vessel or seize the whole or part of the cargo, its equipment or personal belongings of the crew or passenger. So mutiny is the unlawful resistance to a superior officer or the raising of commotion and disturbance aboard a ship against authority of its commander. Okay. As we have already discussed. So how do we qualify piracy? So there are qualifying circumstances, class. Of course, when robbery are committed inside the vessel and it caused the following. They have seized by firing upon the same. Whenever the pirates have abandoned their victims without means of saving themselves. Whenever the crime is accompanied by murder, homicide, physical injuries, or rape. The above may result to qualified mutiny. Qualified, okay. Murder, rape, homicide, are mere circumstances qualifying piracy and cannot be punished as separate crimes, nor can they be complex with piracy. So meaning class, unlike say for example, robbery with homicide, robbery with physical injury, it cannot be complex. So ang tawag lang yun sa iya is qualified piracy. So piracy in parasite in infanticide should be included. So murder, rape, homicide, physical injuries must have been committed on the passenger or complement. In piracy, while rape, murder, or homicide is committed, the mandatory penalty of death is imposable. This means that if the accused enters a plea of guilty, the death penalty will still be imposed because death is a single and indivisible penalty. So since class, it is in our Philippine setup now, death is suspended, so the penalty will be reclusion perpetua. It means 40 years. Okay. If any of the circumstances enumerated under the law is proven or established, the mandatory penalty of death should be imposed. The presence of mitigating circumstances will be ignored by the court. Although in Article 123 merely refers to qualified piracy, there is also the crime of qualified mutiny. Mutiny is qualified under the following circumstances. When the offender abandons the victim without means of saving themselves. So, ganito mo sulod ang mutiny class. They are committed by members of the complements or crew. When the mutiny is accompanied by rape, murder, homicide, or physical injury. So note that the first circumstance which qualifies piracy does not apply to mutiny. Okay. So we have also this, as I have earlier mentioned, the Republic Act 6235, the anti-hijacking law. Okay. Anti-hijacking is another kind of piracy which is committed in an aircraft. So, aircraft ni class ha. So, mag-vessel, piracy. Pag airplane, it's hijacking or aviation. Okay? There are 4 situations governed by anti-hijacking law. Usurping or seizing control of an aircraft of Philippine registry while in its flight, compelling the pilots thereof to change the course or the destination of the aircraft. Okay? Usurping or seizing control of an aircraft of foreign registry while within Philippine territory compelling the pilots thereof to land in any part of the Philippine territory, and carrying or loading on board an aircraft operating as a public utility passenger aircraft in the Philippines any flammable, corrosive, explosive, or poisonous substance. Then loading, shipping, or transporting on board a cargo aircraft operating as a public utility in the Philippines. So any flammable, corrosive, explosive, or poisonous substance, if this was done not in accordance with the rules and regulations set and promulgated by the Air Transportation Office on this matter. Okay? Between numbers 1 and 2, the point of distinction is whether the aircraft is of Philippine registry or foreign registry. The common bar question, okay, ato lang lagi ko ang class. The common question on this law usually involves number 1. The important thing is that before the anti-hijacking law can comply, the aircraft must be in flight. But if not in flight, whatever crimes committed shall be governed by the revised penal code. Okay? So the law makes a distinction between aircraft of foreign registry and of Philippine registry. If the aircraft subject of the hijack is of Philippine registry, it should be in flight at the time of the hijacking. Otherwise, the anti-hijacking law will not apply and the crime is still punishable under the revised penal code. What do you mean by that? So, pwede siya o robbery raang mag-govern under the revised penal code. The correlative crime may be one of the grave coercion or grave threat. If somebody is killed, the crime is homicide or murder as the case may be. If there are some explosive carry, the crime is destructive, arson, explosive, or by nature, pyrotechnics. So destruction of property with the use of pyrotechnics is destructive arson. If there is illegal possession of carried firearms, other special laws apply. So what do you mean? How do you determine class if it is in flight? You can determine if it is in flight if all the doors of the, it does not necessary class, it does not necessary that the that the that the aircraft will fly literally, as long as the outer doors of the aircraft is closed, katong main door, it is already considered as in flight. Okay, so here, so on the other hand, if the aircraft is of foreign registry, the law does not require that it be in flight before the anti-hijacking law can apply. So there is a great distinction, class. This is because aircraft of foreign registry are considered in transit while they are in foreign countries. Sige. So although they may have they have been in a foreign country, technically they are still in flight because they have to move out of the foreign country. So even if any of the acts mentioned were committed while the exterior, napanalulod class. Okay. Okay, so while there is anong karon naman nilulod nga mag-end naman ta. Okay. So I will repeat class that it is considered the aircraft of foreign registry is considered in transit because they are considered in transit because it is not their home state. And the moment they will already in transit, meaning they will pick up only passenger, then ato na po bawas. Okay. Note, under this law, an aircraft is considered in flight from the moment all the exterior doors are closed following embarkation until such time when the same door are again open for disembarkation. Embark, nisaka, disembark. So this means that there are passengers that boarded. So if the doors are closed to bring the aircraft to the hangar, the aircraft is not considered as in flight. The aircraft shall be deemed to be already in flight even if the engine has not yet started. Okay. So there is an example here, class. Oh. The pilot of the Pan America aircraft were accosted by some men and were told to proceed to the aircraft to fly it to a foreign destination. The armed men walked with the pilots and went on board the aircraft. But before they could do anything on the aircraft, alert marshal arrested them. What crime was committed? The criminal intent definitely is to take control of the aircraft, which is hijacking. It is a question now of whether the anti-hijacking law shall govern. So the anti-hijacking law is applicable in this case even if the aircraft is not yet about to fly. The requirement that be in flight does not hold true when it comes to aircraft of foreign registry. Why, class? Because it is considered as in transit. So even if the door of the aircraft is not closed for embarkation, so since it is considered in transit, it is anti-hijacking law will apply. So since the aircraft is a foreign registry, under the law, simply usurping or seizing as long as the aircraft is within the Philippines without requirement that it will be in flight. But it would be different if say they are PAL, Philippine Airlines. This since they are apprehended, so it is considered as kaning robbery. Philippine Airlines aircraft is bound for Davao. While the pilot and co-pilot are taking their snack at the airport lounge, some of the armed men were also there. The pilots were followed by these men on their way to the aircraft. As soon as the pilot entered the cockpit, they pulled out their guns and gave instruction where to pilot. Does the anti-hijacking law apply? No, the passenger have yet to board the aircraft. If at the time the offender are apprehended, the law will not apply because the aircraft is not yet in flight. Note that the aircraft is a Philippine registry. Hope you follow with the distinction, class. So another one, while the stewardess of the Philippine airline plane, so many karon naman na Lord. I will end after this one. Ha? While the stewardess of a Philippine Airlines plane bound to Cebu was waiting for the passenger manifest, two of its passengers seated near the pilot surreptitiously entered the pilot cockpit. At gunpoint, they directed the pilot to fly the aircraft to the Middle East. However, before the pilot could fly an aircraft toward the Middle East, the offender were subdued and the aircraft landed. Okay. What crime was committed? The aircraft was not yet in flight, considering that the stewardess was still waiting for the passenger. Manifest, the doors were still open. Hence, the anti-hijacking law is not applicable. Instead, the revised penal code shall govern. The crime committed was grave coercion or grave threat, depending upon whether or not serious offense by violation was inflicted upon the pilot. So, however, if the aircraft were of foreign registry, the act would be subject to anti-hijack. Okay? Okay. So, as to number 3 and 4, okay, it will apply to public utility aircrafts or okay. Okay. Okay, we'll just finish. We will discuss this crime against the fundamental law of state next meeting class. Probably I will give you an assignment for this one. Okay. So, I believe, I don't know, we will discuss this one. So, as to the number 3 and 4 of RA number 6235, distinction in whether the crime aircraft is passenger aircraft or cargo aircraft. In both cases, however, only two public utility aircraft in the Philippines. Private aircrafts are not subject to okay, class. So if it is private class, it is not subject to anti-hijacking law. Insofar as transporting prohibited substance are concerned. So if aircraft is a passenger aircraft, the prohibition is absolute. Okay. Okay. But if the aircraft is only cargo aircraft, the law is violated only when the transportation of the prohibited substance was not done in accordance with the rule regulated by, prescribed by the Air Transportation Office in matter of shipment. Lagi, yun sa man yung sarbeda. Sagit man. Okay, I believe that is all, class. So I will now check the attendance. Napay ganahan mo sulod, but I will not allow because once I finish the attendance, we will now go. And I will consider a consult. Okay. So we'll start with kaning alpha class. So, Andalas.
Antala, sir. Present, sir.
Okay. Biloy.
Beloy, sir. Present, sir.
Okay. Si Berondo. 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 Siya wala. Si Buskagan.
Sir, present sir, Buskagan.
Okay. Kasihan.
Kasihan, sir, present.
Okay. Duhay Lungsod.
Duhay Lungsod, sir, present.
Okay. Inequela.
Atong excuse kanya sir katong na midjil sa yang iyaan sir.
Okay. Ermita.
Ermita sir, present. Sorry sir, na late ko gamay sir kay nawalan signal diri sir ba.
Okay. Stores. Golem.
William, sir. Present, sir.
Golem. Impiso.
Impeso, sir. Present.
Okay. Lacanaria. Okay. Lagitaw.
Lagitaw, sir. Present.
Okay.
Lagitaw, present.
Ledesma.
Ledesma, sir. Present. Ledesma, sir.
Lontayan.
Untayan, sir. Present, sir.
Okay. Moneral.
Moneral, sir. Present.
Okay. Nanong.
Irene Nanong, sir. Present. Nakajoin ko.
Okay. Ugatis.
Ugate, sir, present.
Okay. Patihan. Patoy.
Patoy, sir. Present.
Okay. Pipito.
Pipito, sir. Present. Pipito.
Redondo.
Redondo sir present.
Remedios. Arikina. Reyes.
Reyes, sir. Present.
Okay. Rivera.
Present sir.
Rodrigo.
Rodrigo, sir, present.
Tagala.
Sir, Tagala. Present, sir.
Asango.
Sango. Present, sir.
Unabia. Villa Cruces.
Unabia, sir. Present. Nakajoin ako.
Sir. Present,
Villa Cruces.
Villacroces, sir.
Okay.
Present, sir.
Okay, so section alpha, you may now leave leave.
Thank you, sir.
Bye, sir.
Bye sir.